Nigeria na walk mpaka Canada. Kana tiku. Kiamo. Acha kama na habari zenu. Sawa. Mwana hata mtakubali. Sababu sasa kwa na kesi tulikuwa naye. Mwenyezi Mungu kwa sababu ya hiyo haki tumepata. Tunashukuru mahakama, tunashukuru wote ambao wanafanya hiyo kazi na tunasema Mungu awabariki na wape nguvu tupate kuendelea. Bila niwahimiza ni kwamba tunapoendelea naomba amani, upendo na umoja katika nchi ya Kenya, tuweze kuwa na amani na mwongozo mwema. Naombea amani kwa askari wetu, wale wote waliotusaidia. Naomba amani ili tuweze kuishi katika hiyo nchi tunayotaka. Amen. Amen. The grace of our Lord Jesus Christ,
it's not as before. Yes, I have recorded Mr. Ndegwa, Mr. Ndegwa, Mr. Mburu. Yes, Mr.
You are present.
Maina, Mr. Kikuyu, Mr. Cheche,
Mr. Gitari, and myself. You are ready for the ruling now. Tukiona kindly we want that so in the morning we didn't have police out here. When we will come back in the afternoon, there are so many police here. We don't know where they are guarding us or they are doing something.
yes, my assumption is that they are just performing their duties.
Your Honor, I'm informed the police officers were out taking charge of the entire site, but the court has since been assembled into one room because the tents out there are no longer in use. So it explains their presence. Thank you.
Okay, we get to the ruling. I'm sorry it was to be 1:30. I think they are about 28 minutes late. Yes, this is the ruling. the matter is fixed for hearing for the 11th, 12th, 13th, and 14th of November 2024. The date was fixed on 22nd of May 2024. Today's successive hearing of the matter was informed by the prosecution information that there were 20 more witnesses to be heard. 9 prosecution witnesses have so far testified and are sequentially as follows. Is Eric by Maina, Inspector Kikuyu, Charles Ndegwa, Corbin Kimani Mung, Inspector Samson Kanwe, PC Atumani Asmani, PC Mashua David, Simon Michelle Yuguna, and Koplo David Nyanjui. When the matter came up for further hearing this morning, and in a rather dramatic turn of events, the prosecution made an application to have the matter withdrawn under Section 87A of the Criminal Procedure Code. The learned prosecutor, Mr. Mung, outlined 4 grounds for the application, which are in short as follows. A, that the prosecution's remaining witnesses are not willing to attend court to testify by dint of their relationship with one of the accused persons. In the absence of such evidence, the prosecution case fails to meet the evidentiary test. B, in count 8 to 12, that requires proof of ownership of the premise where the subject items found in the charges were recovered. The prosecution witnesses lined up to prove that named Njoki is the mother-in-law to the first accused and not willing to testify. Hence, in absence of evidence, the charges cannot be sustained. C, that following this court's direction that the defense be supplied with various requested OB extracts, it was established that the officers who visited the first accused house did not book themselves as required in their respective stations occurrence books, an act that greatly jeopardizes the entirety of the prosecution's case. D, that clause 461 of the guidelines on decision to charge makes a provision for continuous review of evidence, and given the evidence taken so far, it became necessary that the decision to charge be reviewed to that extent given the circumstances. It is for the above reasons that the prosecution sought to have the matter withdrawn under Section 87A of the Criminal Procedure Code. This application attracted the following responses by the counsels for the accused persons. Mr. Ndegwa had this to say. He submitted that in the course of preparing for the defense, he had a teleconversation with Mr. Mung, the learned prosecutor, who did not intimate to him his intention to make the present application. He submitted that the prosecution, having admitted insufficient evidence to sustain the charge, then they should apply Section 204 of the Criminal Procedure Code, which would result in the acquittal of the accused persons. He submitted that Section 87A of the CPC is prone to abuse, as the charges would be reinvented at the pleasure and the convenience of the prosecution. He stated that the nature of the witness' relationship with the accused person is outside the scope that is excusable in law to testify against one another. He submitted that the application of Section 87A of the Criminal Procedure Code is in itself a technicality within the meaning of Article 159 of the Constitution, as it will aid in justices against the accused persons. Mr. Ndegwa submitted on his part that inasmuch as it does not pose the prosecution's application, the applicable section according to section 210 of the Criminal Procedure Code is submitted that in the prosecution exercise of powers under Article 157 of the Constitution, the prosecution is bound by the tenets espoused under Article 10 of the Constitution so as to promote the national values and principles of governance, including patriotism, national unity, sharing and evolution of power, the rule of law, democracy, participation of the people, human dignity, equity, social justice, inclusiveness, human rights, and non-discrimination. Is submitted that in the exercise of its powers under Article 157 of the Constitution, the prosecution should not, as in the case herein, be driven by ill motive of aiding to the use of the criminal process to settle scores, including political scores. Is submitted on the biblical parable of Sultan Court. He called for the application of section 210 of the Criminal Procedure Code, and in the end, he called for the application of section 210 of the Criminal Procedure Code, and in the end, the accused persons be acquitted. Mr. Njiru Ndegwa submitted that the sixth schedule, particularly 7.1 of the Constitution, obligates the court to construe the existing laws with alteration, adaptation, modification, and exception necessary to bring it into conformity with the Constitution. In this regard, it submitted that Section 87A should be dealt with and or altered to be in conformity with the intent of the Constitution. In the context of the case hearing, the learned counsel submitted that discharging the accused under Section 87A of the CPC in the present context would water down the rights of the accused person as guaranteed under Article 50 of the Constitution, as a discharge would make them available to be arrested and subsequently judged by the prosecution over the same facts. Which facts are admitted by the prosecution to be so insufficient to sustain the present charges. He submitted that this charge would only have a meaning if evidence against the accused person existed, in the absence of which the accused person should be acquitted. Discharging the accused person according to the counsel in the present case would make the accused available to being charged at the whim of the prosecution. Mr. Mburu, in associating himself with the four submissions, held the view that Section 204 of the Criminal Procedure Code would suffice under the circumstances, as the state, as the complainant, are seeking to have the complaint withdrawn. He submitted that demonstrative of that the prosecution have not shown any efforts they made towards availing the witnesses. No summons have been requested seeking to compel the attendance of the witnesses. He submitted that the prosecution, having admitted its lack of evidence present in support of the charge, then they should not be permitted to